All right, good morning, Ms. Franco. Ma'am, you're charged with possession of a gambling device, equipment, or paraphernalia. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
From April 15th, 2026 through April 24th, 2026, HCP1 Special Investigations Unit conducted an investigation into illegal gambling at Wade's Fuel gas station at 11350 Homestead Road in Houston, Harris County, Texas. On June 15th of 2026, officer recognized 8 minor video gambling devices and inserted $4 of department issued funds into the machine. After some small wins and losses, the officer won $48 on a $1.50 bet, indicating the machine had been altered, a device violation to allow a player to win more than 10 times their original bet, which is a violation of Texas gambling law. Officer played down her credits to $9 and collected a payout from defendant, a gambling violation under Chapter 47. On June 23rd, 2026, officer inserted $10 of departmentally issued funds into a similar machine at the same Wade's Fuel gas station and won $84.50 on a single $1.50 bet, another device violation. Officer collected a payout from defendant, another Texas gambling law violation. Officer obtained a warrant on June 25th, 2026 to seize the machines. Defendant had 5 gambling devices to seize. The defendant had 5 gambling devices in her care and control and admitted during a recorded interview to making cash payouts for the winnings on the devices.
All right, ma'am, I'm going to find that there's that there's probable cause to go forward with your case. The only condition I'm placing on you now is not to participate in this types of activities again. If you do, I will revoke your bond, put you in jail. Do you understand, ma'am?
Yes, sir.
All right, we're going to have you just sign bond conditions to reflect that. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him, and he'll tell you if and when you have to go back to court. We'll have you sign a reset, and then we'll have you take your seat in jury box,
Thank you
ma'am.
so much.
Yes, ma'am, please. Thank you.
This way. All right, Judge, bottom of 6, Carlone.
So no, guys, can you file no gambling devices, no care, custody, control of any kind of gambling devices on Ms. Franco?
Judge, bottom of 6.
All right, you're Ms. Carlone?
Yes, sir.
Ma'am, you're charged with the offense of prostitution. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On July 2nd, in Harris County, Texas, officers connected a device observed defendant walking around and looking around in front of a motel. The street is known for prostitution. The officer then stopped his vehicle, rolled down his window, and engaged in a conversation with the defendant. She agreed to perform oral sex on him for a fee of $100. The conversation between the defendant and the officer was recorded.
Okay, ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to engage in like-kind activity. Otherwise, I will revoke the bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can we provide you a lawyer today? You want a lawyer?
Is it free?
Yeah, I'll give you a lawyer. Don't worry about it. Just don't pick up any new cases. It's really dangerous out there, man. You never know who you're going to end up with. And just really, life's way too short. All right. All right, please. Victoria, do you mind providing, please? Okay.
Judge, next is top of 11, Domino. Come on up. Go ahead and sign for your.
Hey, are you busy?
What's going on, Judge?
Do you mind just filing the bond conditions on them? Because I know that she's busy. And that was Carlone, C-A-R, no engaging in the same,
Yes, Judge.
please. All right, you said, Victoria? 11. All right, you were Mr. Gamino.
Yes, sir.
Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Gamino.
Okay. Gamino, correct.
On July 13th, 2026, officer conducted a traffic stop on defendant's vehicle for expired registration dated to 2023. The defendant admitted he didn't have insurance. An NCICT CIC check showed defendant's license was not eligible. At least 5 previous Class C convictions for no valid license, insurance, and registration.
Got it. All right, Mr. Camino, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive at all. I don't care what you have to do in this life. You will sign an affidavit with me today. This is a promise that you're going to swear to us today that you're not going to drive. I don't care that you have to work. I don't care that you have to go to school. I don't care that you need groceries. You drive. I can have a contempt hearing every time, punishable by up to 180 days in jail and a $500 fine. Every single time. Do not drive. Do you understand? There's no justification in this life that you can give. If you want to drive, go get a license, get insurance in your name, show it to us, and then I'll take this restriction off. But until that point, you drive. We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. We're going to reset your case. When you come back, please have a lawyer.
Yes, sir.
That way.
That was no driving.
No driving. Yeah.
All right, so next is page 30.
You have it?
Agents, come on up.
Omar, you don't have an arraignment or you have an arraignment?
No, I don't.
No? All right. Let me just go through these real quick. Good morning, Ms. Wiggins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On July 5th, 2026, at 2:33 in the morning, officer was dispatched to a major crash in Harris County, Texas on public roadways. Officer made contact with defendant who had a strong odor of alcoholic beverage and bloodshot eyes. Defendant admitted to being the driver and defendant stated she had 2 shots of tequila. The officer conducted some SFSKs, which were 4 out of 6 on the HGN, 2 out of 2 on the VGN, 2 out of 8 on the walking turn, and 2 out of 4 on the one leg stand. The DIC was red and she blew a .118 and .115.
You see if she have any prior DWIs? And does she have a license?
I sent for the license, all
Okay.
except for the criminal history, she did not have any previous DWIs.
Okay. You mind asking them real quick?
Yes.
Ms. Wiggins.
Other priors in their license and valid.
Right. Thanks, Mr. Kim. Ms. Wiggins, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using illegal substances, including marijuana, I will revoke your bond, put you in jail. No more PR bonds for you. This is not a revolving door. You understand, ma'am? Do you have the ability to hire a lawyer? How do you support yourself? How do you support yourself? How do you support yourself?
I'm not working.
How old are you, ma'am? When is the last time you've had a full-time job?
A year.
It's, you still have to eat, and that baby has to eat. How do you get money?
I got no change.
Great. Is that your only source of income? Okay. Why not get a job? How many children do you have,
I
ma'am?
had lost my ID.
Does the world stop because you lose your ID? I mean, really? How many children do you have, ma'am?
Nobody been hired because I don't got my physical ID. I have to pay my ticket.
Do you mind providing her with an application, please? Ma'am, it's time for you to get a full-time job and you need to get your ID. The world doesn't stop, really. At some point, those kids need more than just, you know what I mean? Okay, we're going to have you fill it out. Do not use. I don't know who you have in this life, but if I have to put you in jail at a high bond and you don't have anyone to take care of those kids, it might not go very well for you. You understand? There are no mistakes in this life. There are choices. You either make a good one or you make a really bad one. All right, come on.
All right, Judge, page 29, Walker, come on up. Walker, action.
Did you want to do that job as part of the conditions?
Let's do get ID first.
That's it for now, Judge.
Okay. No THAs?
Yeah. Oh, I thought.
Oh,
Oh, but he's gone. now.
yeah, he gone.
All right, Judge. Up on 5. It's also BVR.
Baraza. Come up. Do you speak English, sir?
Yes.
You were ordered to obtain your interlock, sir. Did you get an interlock?
Yes.
So one our records show is that he got it on July 10th, but his due date was June 10th.
Ooh, that's. Take a seat for me in the jury box, sir. Appoint him a lawyer, please.
All right, Judge, next is,
You know what? Let's do this. Hold on a second. Hold on. Send him for a drug and alcohol test right now, please.
page 11, Gonzalez, come on up. Gonzalez.
Mr. Gonzalez, do you have a lawyer today? Tell me what you're doing about that. Tell me what you're doing about that.
I can't afford it.
Why?
I don't have the funds.
Why do you not have the funds?
It's too much. I can't afford it.
How many lawyers have you spoken to?
One.
Okay, that's insufficient. Let me ask you this.
Court safe.
Stop. Whoa,
False accusations. I need a court appointed.
I need hair. Is that going to happen?
I mean,
Stop.
I've been here several times.
Mr.
I've
Gonzalez,
seen you don't question
Stop.
other people.
I do. I question everyone.
You didn't
Hey,
ask.
whoa, stop. You have the right to remain silent. Exercise that right. Number one. Number two, this is not a negotiation. This is not an exercise. This is, you need to do what you need to do. Talking to one lawyer is not enough. You may need to talk to 20. You may need to talk to 30. There are a gajillion and one lawyers in Harris County. 99% of them, stop. I want you to listen. 99% of them will put you on a payment plan if you ask.
I don't have the funds for a payment plan.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, now number 19. Tell me, Mr. Gonzalez, on all of those cases that you've had, how many times have you had a court-appointed lawyer?
I'm not sure.
I would like to know. So what we're going to do is I'm going to give you another setting. In that time, I want you to talk to about 10 to 15 lawyers. I want you to bring back a statement. I want you to show me why you can't afford a lawyer. And I'd also like to know on all 19 of the 18 of those cases, how many times you have had a court-appointed lawyer. So it's time for you to buck up, do the research, and then we will talk. But you just coming in here and woe is me, I can't afford this here. Let the county pay for this over and over and over like this is a revolving door. Just not going to happen, sir. Listen,
I don't mean to interrupt, but I've been here a handful of times and you just ask people, can you afford an attorney? They say no, and then they can fill out the application. Since I've been here, you never asked me. You just, the first time I came up here, you said, come back with an attorney. That's it. But I'll go talk to lawyers. I'll bring proof of my financial situation. And
you bringing me stuff on a bar napkin is not enough. I need true.
No, yes, I have.
Right.
I have, printed
What do you
out
do for a living
signatures
now,
every day.
Mr. Gonzalez? What do you do for a living now?
I'm unemployed right now. I try to get a job within the span of me catching this case, but I was let go on my first day because I didn't have a driver's license.
Okay, so let's give him another 2 weeks from now. We'll send you home with an application, but I need more than just the application. I want a list of at least 15 to 20 lawyers that you've talked to and I need more information than just this. Do you understand? I'm going to be very hard pressed after 19 to just continue. The thing is this, Mr. Gonzalez, if I provide my son with a car and I just say, here, go have this car versus making him work to pay for it. How is he going to take care of it if I make him start earning things versus just continuing to hand him stuff over and over and over and over and over? You're on number 19. Do you understand?
Yes, sir.
Right. Look, I'm not going to argue with you. Just, we're going to do it. We'll see you in 2 weeks. All right.
All right, Judge, page
Hey,
24, Ramos, come on up. Ramos.
let me talk to them real quick after this. Okay, to talk to me. Yeah. Hey, I just, hold on. I need a court reporter.
This is Ramos, Victor.
Okay,
You may have 2 hours. Victor Ramos.
okay. What are we doing with Mr. Ramos?
Bond conditions judge, he bonded out. Releasing him. He's got prior bond conditions judge. Yeah.
Why does it show 191 days old?
He bonded most previously, Judge, early January, and then you moved to Galveston County. And now he's out.
Okay, is discovery complete on Mr. Ramos's case?
I'm gonna ask.
Please. Do you know, is discovery complete, Maria?
It looks like it is judge.
Okay, Mr. Ramos, we set cases for trial at 180 days. Your case is 191 days old. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will get 1 setting. At the next setting, you must be back. You must either accept the plea bargain agreement from the state, or I will set your case for trial. That is the deadline for your plea bargain agreement. You understand? So 130-day setting, at that point, it would probably be a good idea to meet with Maria so that you guys go over the evidence. But the next setting, you must either accept it or we'll set your case for trial. If you set the case for trial, we will go to trial. Do you understand? Yeah.
I'll give
All right, so no drugs, no alcohol. Does he have a license?
Thank you.
I need to know if he has a license to drive, because I'm going to order him not to drive if he doesn't.
Oh, he's got a license to go. Do you?
Well, I'm great. Everybody tells me they do, but I need to know. This is Ramos.
Yes. And what's wrong?
Can you mind running his license?
I don't mind at all.
Thank you so much. Veronica, no drugs, alcohol, random testing, no weapons.
It's valid, Judge. Oh, wait. No, never mind, sorry. That's just for a suspension, but it wasn't expired. It's valid, Judge.
It's valid? Okay. All right. So we'll see 30 days. All right. Omar, you ready? No, I'm done. I'm waiting for you. Okay. Omar, tell me what you got.
I have Justin Safucci. And this is a PTI that's supposed to terminate on Friday, but they brought him here on a violation and trying to revoke him from the program.
Is he here now?
He is here. But I just wanted to see if I can get a copy, please, to read out the case minutes.
What's the last name again?
Sartucci.
Sartucci. I remember Sartucci. So I'll give you a week to see whether you can appeal it or not. But at the next setting, if they say denied, he's got to either accept something or we're going to set it for trial. It's 600 days old. Sartucci, come up. What was the violation?
This is the first violation, he didn't get his fees and alcohol, but it's been pretty consistent with non-compliance in this.
It's, I mean,
There are legitimate areas, but
Mr. Sartucci, I'm giving you a week to see whether he can gain you readmittance into the program or not. If they deny you reentry, then you must come back in a week and decide whether you want to accept the plea bargain agreement or I will set your case for trial. You have 1 week. Do you understand? So if he's asking you for information, I would probably get it to him today, at the latest tomorrow, because I'm not giving you another reset after next week. You have 1 week to make a decision on what you want to do. Do you understand? Okay, all right. Thanks. Come on.
I have an agreement to it.
Oh, sorry. Just give me a second. Let me get that. I've got, all right. What is your cause number? Guys, we are going on the record. Please do not talk. If you need to talk, go outside.
3 cause numbers, Your Honor. One's a criminal trespass. Her name is Zaid, Zaiyd. Deborah Michael, GE.
She's on docket for tomorrow.
RE Michael, that's correct.
Okay.
We're gonna resolve it today, Judge.
What did you have in mind?
Do you want me to get the cause numbers for the record first?
Sure.
It's 262-7300, 260-1312, 260-1313. May I proceed? She's been opined incompetent, Judge. We're gonna send her to Harris Center for treatment. We wanted to evaluate her competence and to look at our options for as far as 151s and things like that.
Okay.
In speaking to defense counsel, I don't know that a 151 is going to be appropriate in this. That's going to hold up the probate. Our best option for getting her the help she needs is send her to our public mental health facility, and that's what we're going to do.
Do they still send them to the one on Rusk or?
This one is off of it's 26
Do they still go to Rusk or no?
Russ State Hospital. Or
Yeah,
Russ-
yeah, right.
That would be in for a state hospital commitment. That's not what's going to happen here. These cases are going to be dismissed and she's going to be sent to our public mental health facility, which will be the Harris Center. That way she's at least getting.
Can they get restoration or can they work on restoration or?
That is a possibility here, Judge. I think considering the nature of the cases, what's hurting these cases, I think what's more appropriate, she also has housing, she's got family support. Very often, when we deal with similar cases, that's not the case. Whereas we have a few more resources here with her that might, I think, in talking with defense counsel, are going to be more appropriate towards getting her to a point of stability than anything else where it was.
Okay. I mean, it's up to you guys, whatever you feel is necessary. Just do me a favor. Because you're new on the case here today, do you mind just announcing yourself for the purposes of the record?
Sure, Judge, that would be the proper lawyerly thing to do. Gavin Ellis, Texas.
Right. Okay. And we're obviously here with Justin on Ms. Deborah Michael. So all the case will be dismissed today.
That's great, Judge.
Yep. Okay.
And I'll follow an order after you sign the order. I haven't done it yet because I wanted to talk to you first.
Yeah. Okay.
There'll be 2 orders for the court on each case, right? A dismissal order and then a release instruction order for her to be released tomorrow at 2 p.m. to Harrison.
So we have someone that'll pick her up and take her there.
The Harrison will come on us.
Fantastic. Okay, cool.
Visit her today and give her counsel on it.
Great. Okay. Awesome. All right.
Thank you all.
Off the record. Okay. Are you ready?
Yes, sir.
Come on.
First one is Mr. Michael Gutierrez, that's my agreement.
No problem.
Gutierrez, come up.
Judge, if you could, I assume you're going to listen to probable cause.
Yes. Do you have 2 arraignments?
Okay, pardon?
Do you have 2?
I had 3, but I have,
You want to bring them all up now?
oh, no, just one arraignment.
Okay, got it. All right. Mr. Gutierrez, you're charged with driving. You speak English?
Yes, sir.
You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On July 5th of 2026, an officer was parked in front of the Whataburger when he was flagged down by a witness stating they saw a defendant's vehicle swerving on the road and almost hit the curb before pulling into the restaurant's parking lot. The officer located the vehicle and made contact with the defendant driver who was standing by the car for a welfare check. Defendant was confrontational, had a strong odor of an alcoholic beverage emanating from his person, and admitted to drinking 2 alcoholic beverages before driving. The SSPs were 6 out of 6 in the HGN, and then walk and turn and 1 leg stand were refused. Defendant refused to provide a specimen, and a blood warrant was obtained and executed. There's no criminal history.
Judge, I don't think there's probable cause. First of all, The officer didn't observe anything. Swerving was just conclusionary. He doesn't show he was a danger to himself or others. Almost hitting a curb happens routinely. That's not a traffic violation. The welfare check, he admits to drinking. So the HDN is inconclusive at best since he already admitted to alcohol use. He doesn't elicit any other clues of intoxication other than he's confrontational when an officer comes up and when he's smoking, he doesn't have to answer any questions. He admits to drinking, but he doesn't say a slurred speech, bloodshot eye.
Read it to me again, will you?
Yeah. The officer was
From the beginning.
flagged down, so from the beginning. On July 5th, 2026, the officer was parked in front of the Whataburger. He was flagged down by a witness stating they saw a defendant's vehicle swerving on the road and almost hit a curb before pulling into the restaurant's parking lot. The officer located the vehicle and made contact with the defendant driver who was standing by the car for a welfare check. The defendant was confrontational, had a strong odor of alcoholic beverage emanating from his person and admitted to drinking 2 alcoholic beverages before driving. The SOSCs were 6 of the 6 in the HGN, walked in front of the one night stand were refused and the defendant refused to provide a specimen. The warrant was obtained and executed.
And then most importantly, Judge, as he read that, he never said he lost his mental faculties or his physical faculties. So I don't know where the officer is extrapolating that he can, that's a reasonable belief that the sheriff was intoxicated.
Did you say breath or blood? Did you
Blood.
say that? Blood?
Yeah, the warrant was executed.
And I would argue that there is probable cause. I believe counsel is reading it in the disjunctive, and I would argue that it's in the conjunctive, even though there is an independent eyewitness. The now defendant has admitted that he did drive, so we have operation as for intoxication. Just because he doesn't exhibit all of the clues doesn't mean that none of the clues are there. He did have alcohol in his breath. There was 6 out of 6 on HGN, and there was enough probable cause for a magistrate judge to sign a blood
I
warrant.
don't care about what, but is alcohol in and of itself sufficient?
It's a clue. It's not absent in a vacuum.
A clue.
And striking a curb. And so that's why I'm saying.
Didn't strike a-
Whoa.
Did it not?
Officer didn't see any of this. He's taking whoever, officer.
And he's permitted to do that for a witness.
Sure, I
That's
get
what I
it.
mean. And that's why, so reading it in the disjunctive versus the conjunctive makes a difference because he doesn't require all of the.
Are you losing?
No.
All the evidence doesn't have to come, it's not required that it all come from one witness. It's coming from several sources. One being the defendant himself admitting the operation and the wheel witness stating that he's striking a curb, which is a traffic infraction, but outside of that is obviously a sign. Obviously, it's not conclusive. It's the totality of the circumstances with the alcohol in his breath, 6 out of 6 on HGN, striking a curb and committing an operation.
He didn't say slurred speech or did he have bloodshot eyes,
He's
anything?
mistaken, he didn't strike a curb. He almost struck a
Right.
curb.
Almost hit a curb before pulling the breath.
Did he have bloodshot eyes or slurred speech?
Yes, on the blood warrant, moderate odor of alcohol making with breath, person and staggering, admitted to consuming 2 beers at Buffalo Wild Wings, admitted to the alcohol, did not remember when the second drink was, but prior to that, in the, again, blood warrant, well, he was also combative, but it is consistent with the infraction, swerving on the roadway, almost hit a curb, and no one to the parking lot.
All right, I'm going to find no probable cause.
I'm
All
sorry.
right, I'm going to find no PC.
Okay, yeah,
All right.
Good morning, Judge.
Hey, I can hear you now.
Okay, perfect. My apologies. I got caught in the rain coming back from Brazoria, but I have a Janae Green on the docket, Judge.
Yeah.
It's a BVR. And I wanted to approach on it. I would have.
Are you coming in now? Do you want us to wait?
I've got like 2 pre-trial conferences and another in felony. I think it's pretty simple, Judge, to be quite honest.
I don't
think
agree
it's
with you on that,
an issue
though.
with the-
I don't agree with you on that.
Okay, honest.
Want me to wait for you?
Absolutely, Judge, please. I'll see you shortly.
Hey, just try to get here before noon.
I'm doing my best. I'm getting through here. I'll be there shortly.
Okay, all right.
Thank you, Judge.
That's it.
Top of 2, Alvarez.
You were Mr. Alvarez.
That's fine.
Mr. Alvarez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. She cannot leave. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Sorry, go ahead.
Oh, sorry. On July 5th of 2026, officers at the West Park Tollway eastbound regarding a stalled vehicle on the shoulder of the highway. The officer observed the vehicle on with the keys in ignition and one flashing light appearing to be stranded. The officer observed the defendant and sole occupant slumped over the steering wheel and passed out. Once woken up, the officer observed the defendant to have a hard time rolling the window down and getting out of the vehicle. The officer detected a strong odor of alcohol gathered from the defendant's breath, and the defendant admitted to drinking prior to driving. The SFSTs were 6 out of 6 to HPN, 5 out of 8 on the walking turn, and 1 out of 4 on the one-leg stand. The DSC was read, and the defendant consented to breath yielding the result of 0.149. 0.149.
Okay. Do you mind checking to see if he has a license to drive, please? Mr. Alvarez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or illegal drugs, including marijuana, I will revoke your bond, put you in jail. There will be no more PR bonds for you. I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they may put a detainer on you and you could possibly be in custody for a long time. This is Alvarez. Does Mr. Alvarez have an eligible license to drive?
No, it's valid. But he also has a, it looks like it's just also a commercial learner's permit, but it's not a commercial driver's license, so that's a little bit.
Any prior DWIs?
Oh, no, Judge, just, oh, yes, out of Florida.
I'm now ordering you not to drive any vehicle that's not equipped without an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail as well. Do you understand, Mr. Alvarez?
That's what you said, okay.
Okay, we are going to reset your case to give you time to hire a lawyer. You must also maintain liability insurance in your name as a condition of your bond as well if you're going to drive. For now, I will have you sign a reset. I will have you get with Veronica for your bond conditions, and then we are going to reset your case. Victoria,
Yes,
I
Judge.
need to do guardian and all, please. Okay, all right, come on. Thank you.
Ms. Carlone?
Herman, are you ready?
Yes, sir.
Do you need a translator?
No, sir, it's for Edwin Flores, Judge.
Okay,
He's just asking, he drives all the way to Belmont and he uses his house at 4 o'clock in the morning. He has a curfew right now or some restrictions.
did we already agreed with this, I thought? Did we not?
No, I thought.
We spoke about this a couple of weeks ago.
A week ago, yeah, so, when you approach, we can have your work schedule.
Oh, right.
To come back with work schedule, and we did receive it.
Okay,
So, it says that he needs to go into work at 6 a.m. and when I talked to him, he said that it takes him about 30 to 25 minutes to get.
okay, so 5 in the morning?
Can we do 4:30? Because he asked me for 4 o'clock. He said it was in Belmont.
So then he comes to me, he said that was a second job that he was looking at, but he didn't know if he could get that job because of the schedule.
So if he gets a job, then we'll tweak it, but until now,
Okay.
Yeah.
fair.
okay,
Thank you.
yeah, when you can waive the signature.
Okay, thank you.
Yeah, right. You ready? No, it looks like he's got a license.
Judge, I have 3 matters for today.
Sure, okay,
I have custody clients that I just got to go into.
okay, who's first?
First one would be Mr. Joshua Jenkins.
Jenkins.
Council for recess.
So he's on bond for possession of a dangerous drug. Or I'm sorry, he's on bond for theft. He must have picked up the dangerous drug. Is that right?
Yes, Judge, but Judge, can you go over the possession of dangerous drugs, probable cause on that one?
Sure, of course. Are you guys ready?
For the possession of dangerous drugs.
Yes, please.
Yeah, on July 9th in, Harris County, Texas, the officer observed the motor vehicle, traveling westbound in the 2000 block of the East, FM 1960 BYP. The van showed to have expired motor vehicle registration in NCIC, TCIC, and so the, officer initiated.
Hold on, please, don't talk.
And so the officer initiated a traffic stop and the van stopped. The officer made contact with the driver and the passenger, identified as Joshua Jenkins, identified by his driver's license. And the defendant was not wearing a seatbelt. The defendant showed to have an active warrant through Harris County and was taken into custody during an inventory. And then during the inventory search incident to arrest, of the defendant's backpack, the officer located 15 blue, pills with the marking 100 on them. The officer identified these pills as Viagra, using pill identifier. The defendant advised the officer that he did not have proof of a prescription for these pills. The pills weighed a total of 8.1 grams.
Judge, asked the court to find out probable cause on this one. The affidavit does not establish that Mr. Jenkins knowingly possessed the alleged dangerous drug. He was the passenger in that car.
He says he was a driver.
He was a passenger, Judge.
Didn't you? I thought you said that he was a driver.
Yeah, let me double check that.
I can double check as well, but I believe he was the
Driver and passenger, but it doesn't say. I don't.
For what it's worth, Judge, because the offense report is in fact, it does put him as both, but it came from the defendant's backpack. So, I mean, regardless of the position, it was the backpack from him.
Judge, if he was a passenger in the car, what?
But if he's still under arrest, then they not search incident to arrest?
And then you get to the backpack later, there's no clear statement of saying, was he the driver, was he the passenger, how did they get to it? There's so.
Well, it's a search and they're arresting him because he had a warrant.
He does, Judge, but getting into his property when there are two people in there and also him saying, there's no prescription, he doesn't have a prescription, that doesn't mean he doesn't have the proof of prescription. It just means that he doesn't have the prescription right now.
I mean, if you can provide it later, I'm sure
And I
that,
did offer that if there is a valid.
yeah, I mean,
prescription.
I'm sure that'll kill it, you know, but I mean, I think there's PC to go forward. Sorry. Who's number two?
Judge, he does have and that's pretty much on that one. And then I have, Mr. Adrian Serrato, who is also in custody.
Serrato. That's with an S or with a C?
Serrato. Adrian is the first name.
I don't see it.
It's gonna be on page 31.
Thank you. Okay, so his last name is Adrian. I wonder if that's right. I wonder if that's right.
I can give you the spin number.
Huh?
I can give you a spin number for.
No. I see it, but his first name is Serrato and his last name is Adrian? Does it sound right? I don't know. It doesn't sound right, but. So it looks like he's on bond for an assault with us. He picks up a VPO, felony VPO, and a continuous. Did you any beyond a reset?
That just, we're gonna get a reset.
Yes, for sure. Okay.
And then Judge, I have Mr. Terry Harris, who you wanted on docket today. He is here. He is in the jury box. He has a BVR.
What was the last name again?
Last name's Harris, Judge.
Harris. There we go. Is it a first BVR?
It is his first BVR, Judge, and I have a timeline. I have maps showing that this is not an accurate low, or the number that came out, the result was not accurate.
And okay, how's that?
So Judge, Mr. Harris is in law school. He does take classes. All he did was he got into his car, blew, and he blew completely clean from 152 to 153. At 205, he allegedly blew .08, but he was getting pizza. I have a receipt of his pizza as well. At 208, he then blows another .07, and then he tries it for the third time, and it said it's a violation. He got back in the car at 5:25 and blew clean again. And then after that.
You mean that's 5 hours after the hot blow, or 3 hours?
3 hours.
Or 4 hours?
Yes, Judge. He went to class.
Seems about right.
He went to class. He went from Pizza Hut to class. He was in the parking lot. All he did was eat pizza. That is it. And those were the blows. This is his first BVR.
So the pizza made him blow hot?
Apparently.
What are they putting in the pizza in Pizza Hut?
Yeah, boy.
I can't tell you that.
Maybe the yeast was fermenting?
But
Mr. Harris, come up.
and then there's maps of him showing he went from class straight to Pizza Hut, from Pizza Hut straight to class.
I think they serve beer at Pizza Hut too. Mr. Harris, I'm going to give you any benefit of the doubt. However, you will get a scram on your ankle from now on. Any more hot blows, you will go into custody. Do you understand me? I don't give a rat's behind about excuses. All I care about, bond conditions are bond conditions. I don't care if you're in grad school. I don't care if you go to school with the Pope. You blow hot again, it's not going to go well between us. You understand? Okay. I'm amending the bond conditions with a scram on today, and we'll go from there.
Because he's in school and
He's in school, he picks up a DWI, and it's continuing to have bond violations. So the next bond violation, I will revoke your bond. You understand? It's no tolerance going forward. I don't care if finals are coming up. If you have a bond violation report again, you understand? Okay. All right. You may take a seat. Thanks. Yes, ma'am. Hi. Yes.
This is more of an inquiry for ounce of prevention is worth a pound of cure. I've got a client, he's not on today's docket and doesn't have court till Thursday in his parents' name. He has contacted me. He lives in Louisiana. He had gotten a medicinal marijuana card.
He's not allowed to.
One condition says no consuming or possessing.
Right.
a
No, but he's still not.
substance. And even though he's got a doctor's order and it's legal there, that's where
He's on
my
bond.
interpretation
Yeah.
is on the same page as you.
Right.
Don't do it.
Don't use, there are other ways that you can cope. There are other medications. There's other things that you can do to help. Just while you're on bond, don't use. If he tests positive, tell him that I'm stringing him up in here. Please. There are other ways that you can cope. There are doctors that you can see.
Something, this is a little bit of a confession in my second year of law school. I got it. Best thing that could have happened.
Sometimes it's a blessing in disguise. Yeah.
We're going back to Judge Atkinson years.
Oh, wow.
And, well, this was 32, 33 years ago, but it modified. And,
That's the hope,
and
you know?
I don't regret it in the least.
Yeah.
And no, his brother was killed back from when I was in second grade.
Wow.
At the time, I thought it was fun. But when I got my deal, it was like, oh, George. And I saw what it did to my dad. My dad aged forever.
It's crazy. Yeah, it can have a drastic effect.
It has influence how everybody else.
Please ask him not to, okay? Yeah. Yeah, come on in.
Judge, on Mr. Jenkins, we went over PC, but he still has a warrant on the theft. And I'm going to be asking for a PR bond.
I mean, look, he took off twice on us here. He picks up a new case. The only reason we have him, the criminal history, he just flight over and over and over. So if I give him another PR bond, I know what's going to happen. He's not going to show up. He just doesn't do it.
Would you consider lowering the bond judge? Because there's no way he can afford, such a high amount that he has, 2 kids. He lived in Houston all his life. He just got a job at a plumbing company. But, because he's been in custody for 5 days now, he doesn't know if he's even going to have that job. And there's no way that he can afford that $5,000 bond step onto that.
What do you want?
Judge, I'm asking for 1,000, so maybe it's something if he can come up with at least 100 or.
I mean, I'll cut it in half, but I think that's the lowest. It was at 2,501 before he picked up a new case.
Okay.
So I'll set it at 2,502, please.
That's just, thank you.
Yeah.
May I excuse?
Yes, ma'am.
Thank you.
Mr. Hurd, do you have a lawyer today?
No, I've been speaking with my, trying to get an extension to where I should give them.
I'll give you one final reset, but it's time, sir. Okay? All right, please. All right, 3 weeks. Okay, please. Ms. Pace, you're charged with failure to identify oneself to a police officer as a fugitive from justice. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal once you accept this agreement. You can never change this or undo this. Understand that this will go on your record. If you're on probation or parole, this can be used to revoke that, resulting in further confinement. It's now a minimum of 90 days in jail. Any further Class A misdemeanors. Do you understand?
Yes.
How do you plead to this offense? Guilty or not guilty?
Yes.
I'm going to find you guilty. Follow the agreement. Send it to it. Good luck to you, man.
They'll be filing dismissals on the other 2 cases.
Sure. Okay. Please hit the clerk. Hey. Sorry, Mr. Pearson. You tested positive for methamphetamine. I have to revoke your bond. I'll appoint your lawyer today, but it goes with you. Okay, stop. Just don't. I'm going to appoint your lawyer. Hey, can you please?
Yes.
Okay. Mr. Burnett.
Yes, my approach.
Yeah. Hey, good morning. It's okay. I'm glad that you made it.
But I wanted to approach Judge on this one. I know it's another violation, and I completely understand, and I said the same thing as soon as she called me. I didn't get a call from pretrial services first. I didn't get it word. Literally the moment it blew high, she called us immediately. She had brushed her teeth. She waited 10 or 15 minutes. She washed and rinsed. She has had a few of these issues. She did the 15-minute blows. She did also go and take it and get it calibrated, and she hasn't had any problems since getting it calibrated, Judge. I truly do believe it's an issue with the machine. We're also set for trial and for speedy trial violation hearing next Monday, Judge. I get it. I know it's the extra violations, and trust me, I did tell her, I said, look, you know, you were supposed to have non-alcoholic toothpaste. You know, you can't use.
It's alcoholic toothpaste.
Well, there's alcohol in normal toothpaste. The Crest, they do actually instruct you not to use that. You need to go and get.
Well, that's the first for me. I didn't know. Did you know that there's alcohol in toothpaste? I had no clue.
I did, and only because of BWI cases.
Hey, deputy. Sorry, Miss Green, come up.
Ms. Green is a single mother. She is the only one that cares for her children. We're set for a week. She's been going to her AA meetings. She's provided me proof. She did call me immediately.
If, Mr. Burnett, what happens if I let her go right now? What's going to happen in a couple of weeks?
Your Honor, to be quite honest, what happens is I don't think this case can be proved. I think it will likely end up being dismissed next Monday.
Correct. And if it does, it does. But nevertheless, this is your now second bond violation. I cannot continue. At some point, I become an enabler. Nope. You were completely advised the last time you came here. I admonished you myself. I don't know what to tell you, ma'am, but
I kept raising my mouth and I kept.
Your Honor,
goes with you. Sorry. I can't do it a second time.
It literally, Judge, she blew. It did come back after, I believe. Did it not show? I think there was 4 blows on that day. And I do believe it did come back showing negative literally within 30 minutes, Judge. There's no possible way that it could have went.
That's not, you don't know how everybody's different,
I would
man.
ask that we have a hearing on it.
Sure, I'm happy to do it.
Monday, and we just set it for a full hearing. I would ask that she's not taken into custody.
I can't. It's a second violation, man. I can't continue to do the same thing. I'm happy to give you a hearing with it if you want.
Yes, sir.
We do see, I'm sorry, we do see that she did blow 4 times, but she failed all 4 of those.
It's over, man. I cannot, at some point, I have to say when. I cannot continue. I usually give people a benefit of the doubt.
Yes.
And for some reason, I don't know why I didn't even put a scram on her because that's the normal course of business. I must have not.
Originally had a screen, changed it to the device, Judge.
I can't.
And we know these devices are faulty, Judge. I mean,
Great.
none of them, there's issues with all of them. And I think it's clear to the county that most of these devices and these companies are not sending out devices that are calibrated and correct.
We should have kept the scram on then.
But she did have a scram at one point.
I understand, but I'm sorry.
That's fine, Judge.
Yeah.
I would just ask that the bond only be set at $300, Judge.
I'm not going to do that. I don't do that on anyone. That's not fair, really. I mean,
Judge, I would ask for just $1,000 bond, and she does have a job. She is in school right now for nursing, Judge. I truly believe that this is an issue with the machine and not with her. And the fact that we're only a week away from having a hearing with the case where there's no good witness, an officer that completely omitted a ton of facts in her offense report. I spoke with the state about it. This case shouldn't even still be here, Judge.
to talk to the state now. Maybe they'll do something now, but I mean, sorry.
Thank you, Judge.
All right.
I'll be back.
All right. The top of page 15, right?
Yes, Judge.
Got it. All right. Mr. Harry, you're charged with criminal trespass. You're facing up to 6 months in jail and or 2,000.
Thank you, Judge.
Oh, it is? Got it. All right, Mr. Harry, do you have a lawyer today? Tell me what you're doing about that.
I should need a court money. Get them.
Great. What do you do for a living?
So I just started working.
What are you doing?
It's like the oil field thing. We just move pipes around, make pipes.
Great. How much money are you making a month? You're not going to qualify for going to the lawyer, man. You know, I mean,
I'm not, it's probably like, still about pay rent though. Pay rent, class.
great. This life is not how much money you make. It's about how much money you spend. If you spend beyond your means, that's on you.
Yeah.
People Harris County don't pay for lawyers if, you know, I mean, you have to qualify for an appointed lawyer, meaning you're at the federal poverty guideline, which is making around $15,800 a year. So it's around $1,300 a month. $1,350 a month. You know what I mean?
Yeah.
Right. So we'll give you plenty of time. There's a bunch of lawyers out there, you know, a gajillion and one, talk to them. Just don't pick up any new cases, man. Just be good. We'll give you time. All right. Come on.
Dimitri Bex. He has a bond violation, Your Honor. He picked up
Mr. Bex, come up.
charges.
It's come to my attention that you've picked up a new case, Mr. Bex. What, if anything, has Mr. Bex picked up, guys? Do you mind looking, please?
Is not the burglary of the motor vehicle, something after that.
You have to look outside of Harris County, please.
I don't.
Hey, do you mind helping me out?
Oh, felony chief asking for.
I'm sorry. I just,
What's the name?
Bex is the last name. You have literally picked up in nearly 6 months, 1, 2, 3, 4, 5, 6. You're on bond for 7, and now you may have picked up number 8. All within September of last year. What on earth is going on, Mr. Bex? Stop. It's a rhetorical question, not one that you need to answer, but something with you has changed because all of a sudden you are now picking up one after the other. I have here that he's picked up a PCS and a felony PCS. He's actually picked up 2 new cases. It looks like they're out of county though.
Position of controlled substance out of Caroline, Judge. It was filed in June.
He made a $50,000 bond on his, oh my God, he picked up a delivery case.
There's a. The only out of state judge that I can pull up is the one in Caroline. Was filed with Danielton, District Attorney's Office, possession of a controlled substance.
Is it a 4 to 200? I'm showing that he's picked up, he first picked up a new law violation on 7/1. And then he picked up another law violation, a 4 to 200 grant case. Well, it looks like it's the same day.
Step back up. I have a small emergency, actually.
Go. Regardless, Mr. Betts, you've picked up a couple of cases while you're on bond. The only thing we told you not to do was pick up the new case, and now you've picked up 2 felony cases. I'm revoking your bond. The deputy, he's going to go with you. Sorry. I'm sorry, Mr. Albert. He'll roll up on tomorrow, but he picked up 2 cases, one of them being a 2nd-degree felony, man. I can't just continue, you know? Are you representing him over there?
I'm not.
No? Okay. He will auto-populate on tomorrow's docket, unless he bonds out. I guess we'll just let you know, you know?
Yes, Your Honor.
Yeah. Okay. Thanks, man.
Thank you, Your Honor. Bye-bye.
Judge, what's the new bond amount?
10,002.
10,002?
Yeah. Miss Davis, come up. Do you see how many people we've put in custody today, ma'am? We don't take it for a joke. When we ask you to take a drug and alcohol test, we want you to take a drug and alcohol test, and it must be a legitimate lab bearing legitimate letterhead from the actual test, because what we do is we call them to verify to ensure that everything is accurate and it's done and that it's legitimate. So when you send stuff that's not, looks like it's on a bar napkin, it's just not going to fly. We're going to send you for a drug and alcohol test now. If you live out of state, if you get called to test, you must do it the right way. It's got to be done at a Quest Diagnostic. You understand? I'm not going to have this discussion with you again. I've tried to do this several times. I'm just not going to have this discussion again. I have enough drama in my life. I just don't need any more. So we will send you for a test now, and then we'll go from there. I mean, hopefully it's negative. If not, we'll have to deal with it at that point. Okay? All right, ma'am, just take a seat for me, please. Thank you, Mr. City. Sure. Hi, Sebastian.
I just wanted Hanson on the bond docket for plea.
Okay. Arnold Hanson, come up. Good morning, ma'am. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 90 days in jail with credit for the 38 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. If you are on probation or parole, pleading guilty can result in further confinement as well. Do you understand? Is this what you want to do? How do you plead to the office of theft, ma'am?
Your Honor, it was the burglary. I'm not sure.
Let's take that. Oh, sorry. It's the charge of burglary of a motor vehicle. How do you plead to the burglary of a motor vehicle, ma'am? I'm going to find you guilty. I will follow this agreement. You need to understand, ma'am, that this is an enhanceable offense. If you continue to pick up burglary of a motor vehicles, number one, you may either get shot because people like their guns and they like their cars, or you may be hit with a felony next time, years instead of days, because could be enhanced to a felony. You understand? All right. Good luck to you, man. And then that will be dismissed. All right. Good luck to you, man. Mr. Alonge.
Yes, good morning, Your Honor.
Hey, good morning.
Yes, I'm here on Clarkson.
Bottom of 7, Judge.
It's a bond violation.
Is Claxton here?
Yeah. He's not here. I can see him.
Okay, he didn't check in.
He did check.
Your Honor, it looks like he checked in, but they sent him out for drug test.
Oh, he did check in.
Yes,
It came back presumptive positive for THC.
I was in court earlier and I saw him, but he went for drug testing.
Is Mr. Claxton here?
Oh, he just walked in.
Come up, Claxton. We ordered you not to use. You're not to use alcohol or illegal drugs, including marijuana or anything that has marijuana in it. I will give you the benefit of the doubt from the time that we ordered you not to use. It'll be 40 to 50 days. If you test positive again, it may not go well between us. Do you understand?
And he has all these conditions, related to the day mark, which is July 28th.
All right, so let's set him, we'll give you a benefit of the doubt. We'll set him 3 weeks from today. Don't use. Do you understand? The next time you test, all right?
Your Honor, the other thing, Your Honor, is he lives in Conroe and he mentioned he does not have transportation to come for the random testing. So I wanted to see if you'll allow him to do it in Conroe.
It has to be at a Quest diagnostic, and I can't pay for it. You'll have to pay for it yourself, but it'll have to be at a Quest. That's the only way that we'll do it, that we'll accept it. So it'll be up to you, however you want to do it, but at the next setting, you must test. You understand? All right, so Victoria.
Thank you, Judge.
It's on Mr. Claxton.
3 weeks to drug test again?
Yes, ma'am.
Okay. How is August 4th through the 6th?
August 4th, August 6th is fine.
Okay, thanks.
Thank you, Judge.
Take care. You ready?
I do it.
Hi. Yeah.
Judge, I was appointed to Mr. Arcadio Baraza this morning.
Okay.
So DWI second, you sent him across the street for a random. He is negative. And looks like it was a BVR.
I have a problem with this. Come up.
The allegation was that he didn't get his device on time and it didn't get it
An
recalibrated.
entire month.
You know, Judge, here's the thing. He's showing me receipts where he did get it. He did get it installed on June 10th. And then he got it.
Show it to them, because I mean, according to Veronica and pretrial, he just got it.
Right.
And the only reason is because we hauled him in here.
Gotcha.
So, I mean, if you can verify with them, great.
Okay. Veronica gave him an email address. He's emailed the receipts to pretrial services. And so. Okay.
So I guess let's just hang tight for about 5-10 minutes and let's see what they say.
That sounds good.
Yep. Okay.
Judge, you ready to go over?
Please.
Bottom of 3 was THA failed to appear.
2501.
Page 4, counsel approach.
No, Victoria.
Oh. Top of 6, simple agreement failed to appear.
2501.
Bottom of 8, required appearance, defendant failed to appear, counsel came by looking for.
5001.
Page 9, bottom, simple agreement failed to appear.
2501.
Top of 13 is THA, he called and said he didn't have a right.
I guess, what's the best day?
I asked him, "Did you have a certain-" He said, "I don't have a."
So call him back, and when you get in the day, say, this is how you need to do it, and let me see.
All right, Judge, next is top of 14.
So any day this week, I guess, I don't care, whatever's best, SFBF.
Okay, top of 14, is it, they failed to appear on their arraignment until the second time.
Okay, 5001. Hey,
Morning, Judge Member.
please.
I'm here for Mr. Cameron Valley.
Okay,
You're here on DWI PTI side. We're still trying to figure out some details about his license, the eligibility of his license before the state will give us the PTI contract to sign.
is it suspended or is it not suspended?
That's what we're confused about, because he has a license with him that was issued in May of this year.
Well, I get it, but it may be suspended on the state side. Just because you have a license doesn't mean it's eligible.
Judge, it's not that it just doesn't even show up on our system. We don't have a trace of his driver's license number. I ran it through, I had the same issue.
So did you run it under other identifiers other than that number?
Yes, Judge.
Under the last name and?
Yes, it's just a new driver's license, it even looks different, so I don't know, maybe it's just that.
No. If they're going to give him a license,
Yeah,
then it's going to be in the system. There's not going to be, you get a license that's not in the system, otherwise, unless it's something that's fake, right? Or it's somehow different, but I mean, the case is 180 days old. I mean, I'm not going to just continue to reset it in hopes that stuff gets better.
the only thing that PTI asked us if they can get a confirmation from GPS that this is a legitimate license.
Great. All right, we'll set you a week, but no more wait. Your client, is your client here now?
Yes, sir.
Okay, do you mind bringing him up, please?
I'm not sure what happened, if they just taken.
Something's, no. If you have an actual license, it should be in the system. If they don't issue one, first they issue the paper, then you get the actual license. They're not going to do that. Something's amiss. It doesn't, hey,
Good morning, Judge.
please, come on.
I have Calvert on the docket. He is in custody, Judge.
Okay,
I'm just approaching to request that the bond be notarized 2 cases.
the bond be what?
bond loan.
Lower.
Yes, currently on the UCW from offense state,
Oof,
429.
15,000, huh?
15,000,
Yeesh.
and then on the evading is 5,000, I'm requesting 500 on both.
Oh, well, that's why.
Yes, the felony attorney
Just
also.
do me a favor. Just let me talk to him and then, because yours is going to take a little bit longer. Come on up. So understand that at 180 days, we set cases for trial. We have to kind of keep continuing to trim everything. Otherwise, the docket's balloon out of control. You're at 180 days. There's something wrong with the license. So they're asking you to provide proof that you have an actual license so that everything jives together. It is up to you to get the proof from DPS. So when you call DPS, you need to call them at 7 a.m. Otherwise, you will never get through. Call them at the driver license division number, and then you will get through. If you try any other time, they're just way too busy. You'll just never get through. I'm telling you from my 25 years doing it. The only time is as soon as the phone lines go open, which is 7 o'clock in the morning, I would call at 6:59. That way you can get through and somehow get proof to them. You're at 180 days now. I'm not giving you any more long resets. So I will give you a week to get this done. If you don't get this done in a week, I'm going to bring you back day for day until you get it done. Do you understand? Okay. All right. Good luck, guys. Please.
Wait, so I have to call both my DPS on?
I would call is it 512? It's 512, right? I would call the 512. Don't just go to DPS because they're so busy, they're just not going to see you. You need to call the 512 number to the driver's license division. It's easily Googleable. Get it and call them, but call them when the phone line's open. And then somehow you need to get them proof because they're running your license and it's not appearing on their system. So something's not right. Something, maybe they have you on the last name is spelled incorrectly, the number's off, something. And so before you are granted entry into the program, they need to make sure that everything lines up correctly. Okay. Okay. Well, I mean, I'll give you up to a week. I know that people are busy, so we'll give you a little bit of time. Just don't wait till the day before to try to do it. And then, oh, damn, something happened. That's a good idea to do it tomorrow, though.
What do I do after I get
Well, I'll let your advise you. So you need to get some kind of proof or something that you are who you are and that you have a license. This is the number so that they can verify. Okay. All right. Good luck, sir.
Thank you.
Thanks. Yes, ma'am.
Right this way.
Thanks. Hi.
Show your phone.
Yes. Okay. So we're talking about Calvert.
Yes, Your Honor.
Calvert. Yeah. So Mr. Calvert, he's on bond for a gun case. Presumably we told him not to have a gun, right?
Let me check the law commissions. Presumably, yes, Your Honor.
Oh, Singer did it. So I mean, the presumption is wrong.
Yes, I don't see it either.
Well, they usually sign general conditions when they get out, but not one that I put on. So what happened with the newest case, if you don't mind? He picked up an aggravated robbery.
The aggravated robbery?
Yeah.
In the aggravated robbery, it was March 24th of 26, and the complaining witness stated that he was walking his girlfriend's dog in the apartment complex in Harris County, Texas, when he was attacked from behind. The complaining witness was carrying a firearm on his person, and when the complaining witness was attacked, the defendant took the complaining witness's firearm from complaining witness and pointed it at the complaining witness while pulling the trigger. The complaining witness said that there was not a round in the chamber, and
oh my God,
the fire defendant ran away from the complaining witness. Complaining witness chased defendant through the apartment complex. Defendant was able to cycle to the side and load around into the chamber of the firearm.
Ms. Mogadishian, complaining witness is lucky to be alive.
Defendant began shooting towards complaining witness and striking the complaining witness in the leg.
Say that again?
Defendant began shooting towards complaining witness, striking the complaining witness in the leg.
I have and I believe the felony attorney also filed a motion for competency evaluation, which I also have mental health.
Please, or I mean, yeah, but I think that
he's been in custody since the case is judged. It's been about 3 months and he hasn't been able to make any bond.
I don't know. This is the first I'm hearing about it. I don't remember even. Have we spoken? And when did you get appointed?
I was appointed originally, on the first case a while ago, and then he picked up the two newer cases. The first case was appointed on, April 1st.
Was it a Tubi or something? I don't understand. Why is it
It
so?
wasn't, they took a while to file that felony.
I'm sorry. I think that bond is appropriate at this time. I just.
Is that your family word?
Yeah, I think that he's. I mean, that's really scary. And. Hey, Veronica.
He has no criminal history prior to.
Sorry.
Do you anticipate him bonding out of the felony?
His fiance was here this morning explaining to me that her and his mother are trying to work together to gather some funds to post the bond.
So we're talking about Mr. Calvert. So Mr. Calvert, I'd like to do a GPS prior to release, and I'd like to do a curfew. I don't know what kind of bond conditions the felony has put on him. Let's see. Yeah, it looks like they're set a competency exam for. So I'd like to do no going within 1,000 feet of the complex or the complaining witness, please. With the GPS monitor, no alcohol, no illegal drugs, no weapons, no contact with the complaining witness. I don't know. Let's do the exam first, and then let's talk after the exam.
Okay.
Okay. So have you ordered one yet?
I did not, I was going to, but then I saw that the felony attorney did already. I did email
We can
her.
piggyback on that.
I believe we can. I reached out via email to her to request if it was completed or not, but I got an automatic out of reply for.
So set it for just a couple of days and let's come back and let's talk about it.
Okay.
Yeah?
Okay.
Okay, yes, ma'am. Hi, Mr. Burnett.
I just reapproached briefly.
Sure, of course.
And it's on green again.
I understand. Dude, you're not gonna hurt my feelings. If you come up 15 times, I don't care. But I have also, but also I hope you appreciate that I cannot continue to enable and I can't continue to say, at some point, I have to hold you accountable. And if I don't, then it's on me and then you can continue to violate and then the orders have no teeth,
I truly do appreciate it. And there are people that I do have that I'm like, okay, they have a problem.
But it doesn't mean that she has a problem. It's just there are bond conditions. You either choose to cooperate or you choose not to cooperate.
But my problem is just that I don't think these machines are working well. The same way we look at a DWI case and we have these breathalyzers where there's 0.2 difference within 15 minutes. We have a blow that's a 0.054 to a 0.049 to a 0.039 to a 0.07. Like these numbers, they don't even make sense.
Meaning someone's eliminating and then they take a swig and so it goes back up.
Do we really think that?
I don't know. But I mean, I wasn't there. I don't know. She's blown 4 times. She's blown hot 4 times. That's all I know. I've already given her the benefit of the doubt once. I'm not going to do it again. It's not going to happen. I can't. Sorry.
Thank you, Judge.
For sure.
Bottom of 25. Except for when we fell to here.
2501.
Top of 28, same thing.
2501.
Bottom of 29, Walker.
What? Okay.
He was here and then he just left.
Okay. 5001.
Top of 7, Judge, is a petition for non-disclosure. State is opposed.
Top of who? 7, you say?
7.
On Carter,
Yeah.
Carter?
is the defendant here? Carter, come up, sir. So you filed a motion for non-disclosure on the terroristic threat, is that right? So a lot of times when the state is unopposed, I grant it. But for some reason, the state is opposed in your case. So we would need to have a hearing. It's probably a good idea for you to have a lawyer because the lawyer can help you argue these things as opposed to you doing it yourself because you know, they're going to get into code sections and all this stuff. And if you don't know what you're talking about, they're just going to may not go very well. So what I'm happy to do is give you a couple weeks so you can try to talk to someone and have them come in so they can try to argue on your behalf or whatnot if you'd like to. Otherwise, we go forward. So, I mean, I'll give you one setting to do that. And then if you just want to, you decide what you want to do, you know? Okay, please. Can I talk to you real quick, Mr. Kim? I know that you like to write things down, so that you're very judicious in this respect. So I'm talking about Mr. Carter.
Okay. Oh, yes, I was actually looking at that right now.
Okay, so no. The only thing I'm going to tell you is that I just brought him up. You guys are opposed. I don't know why, but it doesn't matter. I told him that it would probably be a good idea to hire a lawyer, to have a lawyer at the next setting to argue. But at the next setting, we go forward, whether he has one or not, so that you can make the proper notation in your setting so that you guys are also ready. So, you know, I don't know whatever date Victoria gave him, but the next setting we go forward, whether he has a lawyer or whether or not. I advised him it's probably a good idea because they're opposed. So
I'll put in the relevant code. I just wanted to double check which provision of 411 that I was using, but.
I don't know, but it's, you know, if you guys are unopposed and as a matter of course, I always. Right.
Without even looking. Yeah.
I mean, just. It's great when people try to better themselves, but if you're opposed and there's a legal reason and we have to get more into it, you know?
I don't know if this is one of the ones where it's a shall. And so I'll double check because there's certain enumerated offenses.
Yeah.
And so let me double check.
Right. And it's what.
It's because it's a domestic, but it's not an assault. It's a terroristic, but I still think it's governed under the violent part, but that's why I'm actually double checking.
Okay.
Thank you, Judge.
Yep, for sure.
Judge, do you have any hearing dates this week?
For what?
For the speedy trial violation on the screen. It's set for next Monday, but seeing that she's taken into custody and the state is still just releasing evidence. I just got the search warrant for her from Bud today. They just released it right now, just quick button. I think it's imperative that we don't continue to have her.
She's on docket, no?
Ms. Green? Yes.
Oh, Green. Why was I thinking David? I mean, it's only 110 days old.
It's only 110 days old because it's waited 6 months to file it.
But they have 2 years.
I understand that they have 2 years, but that's still
we've had cases where they filed it the day before the statute runs, you know?
I understand that, but there's a lot of issues that are created by this lack of diligence by the state, lack of diligence by the officer. There's a lot of other issues without getting into.
I'm happy to have it whenever you want, as long as they're ready as well. So if you want to have it later in the week, as long as we've got Ramona, we can do it on the record and you're ready, Ms. Shaw, I'm happy to. You guys pick the day that you two are good with, as long as you're ready. And I want to make sure that you're ready as well as him so that you're not kind of taken.
Well, I would say this week, just we already have our high school with baby VA school and Karina in trial and there's just a lot happening. It would be great if we could do it next week.
And if there is going to be one for the motion, state just requests a 3-day notice for, because I haven't seen the motion. If it is, I apologize, I haven't seen it. So for whenever the motion filed, at minimum 3 days, but at maximum a week until the normal fee comes back, because I haven't seen anything for the basis of the fee.
The motion's been filed, I believe it was filed a month ago. We were already set last week to have the hearing.
That's why I said I haven't scrolled down, so I.
No worries, no worries.
You know, and I would also, Mr. Brennan, be ready with case law supporting your position as to why, 30 days, 60, 90 days, 110 would be.
I've got a ton, it's already in my actual briefcase. I had it ready for last Monday.
So may I have the date that I can't seem to find it, if you could help me?
Yes.
Are you ready?
Yes, sir.
Okay, talk to me.
On Mr. Baraza,
Okay,
there's got to be some administrative mix-up. Pretrial services is showing a 7/10 installation date.
that's what we're talking about.
Right, but Mr. Barazo, he has a receipt for 6/10 and an installation, and he also had just showed me a picture of him blowing into the device on June 26th.
Okay.
A friend of his took the picture of him blowing into the
He
device.
should have all types of blows then if he's blowing into the machine, because they should be taking this picture, so he.
Pretrial services is saying that they only show blows starting on July 10th. So Mr. Barazo says that he has a receipt at home that should show installation date and recalibration date. He doesn't have that receipt with him.
Okay, so roll it to Wednesday. We'll have a hearing on Wednesday.
Fantastic.
Yeah, okay, all right. Okay, guys, we're done.
So.